Legally Speaking with me, Tarun Nangia. This is a very, very important series. This is about Justice Suryakant's vision and mission via a program called Mediation for Nation to reduce pendency of cases. And it is very interesting because he said, not only will I work, but I'll give you my report card. And how is that going to happen? He shortlisted 1.69 crore cases, 32,000 mediators are working. And after that, sometime in the month of October, the National Judicial Academy at Bhopal will look into this. After looking into this, we'll get a report on what has been achieved. That is why, as the executive chairman of NALSA, Justice Suryakant has said that I'm going to do this program and I'm going to show you what has been achieved in terms of disposals of cases. We also expect that this will continue in some another form when he takes over as the Chief Justice of India. Given the kind of tenure he has, a lot can be achieved. But it is heartening to know that a judge of the Supreme Court is talking openly about what he aims to do and that he will sort of share the results with all of us to see. That is something that we are happy about. And I want to welcome today on the show Advocate Avishkar Singh. He joins me today. Good to see you, Avishkar. Thank you for your time. I have with me Advocate Karthik Seth, Advocate Aditya Ajgaonkar, Advocate Karmanya Singh. Good to see all of you. And let's get going with the show. I'll ask Advocate Avishkar Singh to give the opening comment on Justice Suryakant's vision and mission via Mediation for Nation. Over to you, Avishkar.
Just to say it in a short way, I think, yes, we all would commend and welcome this initiative, the impetus given by the CJI designate nearly now. And, you know, this sort of thing, his tenure, which is spanning over just over 1.5 years, will allow him to make some considerable reforms in the times to come. But, you know, mediation has been lingering on, as we all know, from a long period of time. And it hasn't seen the right push and the initiative taken by a senior jurist. So Justice Suryakant taking this initiative, the law has already been in place, and we are all aware of Section 89, the ADR, and you know all of those available statutory mechanisms. But the initiative, the push, the intent behind Justice Suryakant's push for alternative dispute resolution through mediation to declog the arteries is a very welcome push. There are certain caveats which we can discuss further in the show of how this thing should play out and what is the desirable manner in which mediation should be conducted in our country. Obviously, institutional mediation is now statutorily prescribed in the 2023 Act. So there are certain safeguards. But however, it's all about the mental attitude towards mediation. If mediation is the bridge between conflict and resolution, and if mediation is really the facilitator, the humane facilitator of dispute resolution, then I see it as a real welcome step in our country's jurisprudential progress, and also to let courts dedicate their time to more complex constitutional issues, which they are really meant for. Thank you.
Thank you, Avishkar, for that opening comment. I'll go to Advocate Karthik Seth for his opening comment on Justice Suryakant's vision and mission with Mediation for Nation.
Yeah, thank you, Tarun, for having me among such esteemed panel. I completely agree with what Avishkar just mentioned with regard to the vision of Justice Suryakant. And I mean, it is very great to hear that he's the CJI designate, because actually time really flies. We were just talking about Justice Gawai as the CJI designate, and now we have another CJI in the very same year. The only thing which I would really look forward to is that, which I really hope and I'm sure about it, is that whatever good work Justice Gawai has done, that will be continued. Because I mean, there's a famous saying by a United States Supreme Court judge, which says that usually chief justices of countries get only enough time to undo the work which have been done by the previous chief justices, and their whole tenure just goes in doing that. I really hope that the next 3 chief justices just add on to the good work which has been done, rather than focusing on anything which has to be undone of the previous chief justices. Coming from there, already Justice Suryakant is hearing a matter which is about rehauling the Supreme Court rules of 2013, where he has already appointed amicus. And coincidentally, I was talking to the amicus in Supreme Court today itself, And they were saying that it has been suggested by Justice Suryakant to even have a mediation section even in the Supreme Court. So that pre-suit mediation is there in commercial court, in a high court, in all the commercial matters. If the same is brought in Supreme Court under the aegis of the Supreme Court rules, where it is said that anyone who comes to the Supreme Court, you need to you need to specifically first go for a pre-institution mediation before your SLP is admitted or before your SLP is filed. If there is urgency, obviously you always have the right to immediately move. But if there is no urgency which has been made out, you first go mediate. If there is mediation possible, then you come back with the report, and then we list your matter before the Supreme Court. In Supreme Court, there are such high stake matters that sometimes the urgency is very quick, that the client comes to us at the very last minute and says, I want my SLP listed tomorrow. But in cases where there are civil appeals are basically statutory appeals from APTIL, NCLAT, and other tribunals. There, in those cases, I believe this would be a very, very welcome step. And Justice Suryakant is absolutely right that mediation is the way for the future. And as I'd spoken on your earlier shows as well, how it is working out these days, EMW, or it's R. Venkat Ramani's, the Attorney General's mediation conference, Mediation Bar of India. Definitely, Mediation Bar of India is going to be the thing in 2015.
Thank you, Karthik, for that opening comment. I'll go to Aditya Ajgaonkar, who joins us from the city of Mumbai. He's at the Bombay High Court. Aditya, your opening comment on Justice Suryakant's vision and mission with Mediation for Nation.
Tarun, we've spoken about mediation. My esteemed co-panelists have explained that in detail. So I'll focus on the nation aspect of it, to avoid repetition. I really like the fact that, there is emphasis being given on reducing pendency across tiers across the nation. We are not just looking at, the docket of a particular court, maybe the Supreme Court, the High Court. A lot of our litigation is, the parties are private, and mediation will be able to really help with that. I do not know how much mediation would help where, government is involved as one of the parties, because I don't think that really works out, though a overwhelming, percentage of the docket of the Supreme Court, especially, and even of a lot of our high courts, is burdened by matters where the government, usually the state government, central government, or even a local body government, municipal corporation can be a party, where mediation would be very difficult because policy travels from up to down when it comes to taking decisions, but when it comes to simple events, like say family members fighting, a lot of testamentary matters could be laid to rest. A lot of issues of property disputes could be laid to rest. Usually because people do not realize the amount of time, energy, and money that will go into prosecuting a suit till it is actually decreed, then, perhaps seeing it through various appeals and then getting the decree executed, right? It takes a lot of time, and very often, because it takes a lot of lawyers, it also can take quite a bit of the money, and there's a catchphrase, operation successful, patient dead. It could happen, for a lot of these cases. So the mediation that is done right at the start, especially for matters that can be resolved across the country, especially at the municipal level, at the district level, and perhaps even at the high court level. Not all high courts have an original jurisdiction, of course, but wherever the high court has an original jurisdiction, I think that would be a fantastic initiative. And I think that is exactly what Justice Suryakant is looking at when we look at the numbers that you actually talk about. When you're talking about disposal of a crore plus cases, 30,000 mediators, the scale is on a nationwide basis, right? So I think that will be a game changer if, of course, it is followed up. It is not just Justice Suryakant. Everyone will have to contribute towards it. This is not something that, even if he is the Chief Justice of India, or the Chief Justice designate, it cannot be a one-man show. He will need the cooperation of a lot of stakeholders, and I'm glad a lot of stakeholders will be able to assist in this noble endeavor.
Thank you, Aditya, for your opening comment. Indeed, 32,000 mediators high courts, district courts, all on board for this, getting pendency levels to a control level. That's the endeavor. We will go to Advocate Karmanya Singh, who is currently abroad, but kindly sort of consented at a quick notice to join us. Thank you, Karmanya, and want to know from you, what do you feel about this ambitious vision and mission of Justice Suryakant via Mediation for Nation?
Yeah, so I think I'll explore two aspects of it. So being an engineer, an electronic engineer running a software startup on the side while I do a law practice, I think for any efforts like this to be meaningful, there have to be certain principles that should be laid out. And I think technological support or having principles that people can use technology to make mediation convenient, that should be very clear from the top down. I think a lot of times at the district levels, even in family disputes, the whole logistical effort of going to mediation itself can be so painful that people are already so tired that even if they don't want to end up in litigation, they don't want to end up fighting, the effort of resolving disputes or discussing it or having confrontations, that gets quite painful. I think secondly, for there to be any mediation between the government and individuals, Aditya, there's a very interesting point that I worked on. So for traffic challans, you can go to V courts and you can pay fines, but there are lots of issues there as well in terms of being able to do it within the 60-day period, in terms of being able to do it online, in terms of being able to do fines. And if you do it actually online, if you need the fine print, you're forced to plead guilty when you pay a fine on V courts and you get technically convicted. So these issues we've raised in court. I've personally done a matter where we've raised it before the Supreme Court. So I think the ambition is big, but the stakeholder involvement for meaningful resolution, you need to empower the mediators, empower the lawyers, and push for reasonable understanding. Because for all the criticisms that we have for arbitration in India for complex disputes, for simple disputes, for straightforward disputes where parties want to avoid litigation, parties want to get out of fighting with each other, especially their loved ones, or in very small disputes against the government for challans, I think it can drive a lot of disposal down.
Thank you for your opening comment. Now we will move on to the section where we give our good wishes to Justice Suryakant for this ambition program, along with one suggestion that you would like to give for better implementation of Mediation for Nation, and of course, which can be taken up in the 1.5-year long tenure that Justice Suryakant has. Because of course, I don't think this program going away. This result will be out in October, but we will also have another program that will start when he takes over as the Chief Justice of India. We will start with Advocate Avishkar Singhvi.
Well, I'm sure that Justice Suryakant, with his wisdom, has and with his able team of advisors, has already covered all the bases. But and the advantages of mediation, we are quite clear with. It's faster. It deals with it's confidential. It's personal. It's informal. There are innumerous sort of advantages. But the suggestion that would come from my side is how do we identify natural mediators? Now, a mediator does not, in my opinion, even need to be a lawyer. In a lot of situations, I've seen people who have that gravitas and that influence over people that they are able to get two people together and to tell them that, look, now you both come to a conclusion. To identifying natural mediators, apart from the fact that mediation service providers have to be registered in the act, etc., and once they fulfill all the safeguards, but number one is professional natural mediators. That's number one, identification at that stage and the filtering mechanism. The second stage, as constantly auditing and supervising mediation progress in matters. So how does one keep track of mediations that are pending and that have been matters that have been sent? Otherwise, it should not just become another form of litigation. It should not just become another form of endless loggerheads and completely delaying the process even further. So I would suggest that is one. The other thing is having a reputed panel of mediators who people can select once they know how effective they have been in the circuit. Infrastructure, I'm sure Justice Suryakant has already answered that, because they have invested a lot in the infrastructure and there's a huge push from the government, supported by the government, I'm sure, on this issue. The third thing is that how do we ensure that the awareness and the attitude to go to mediation? And in fact, it should not come at the cost of despising and sort of castigating litigators, but it should come as a natural first option. So what is your choice of first resort should be mediation. And that happened with Justice K.M. Joseph's famous judgment on the Commercial Courts Act, where he said that it is a mandatory precondition under 12A to go to mediation. But that judgment has been further been clarified in other judgments, that should naturally be the first option for any litigator to go to mediation and try to resolve it. Actually, I'm saying this, it's against all of our interests on this panel, and we would have to look for a new career option. But I'm saying this with a lot of heart, to say that our litigating sector needs to be declogged, and we need to focus on matters which are really, really laying down the law. And we cannot be just deciding dispute which are to be, you have to arrive at a number. So those would be my constructive suggestions.
Thank you for your closing comment and your suggestion. I'll go to Advocate Karthik Seth for his closing comment, suggestion, and good wishes for this program titled Mediation for Nation.
Yeah, thank you, Tarun. So, as Avishkar rightly pointed out, definitely, probably those suggestions and everything would be in the mind of Justice Suryakant and his advisors. But still, the first thing which I would really want to say is I heard Justice Karya saying during this Delhi arbitration week sometime in one of the shows that mediation and arbitration are not alternative dispute resolution. So we need to remove that word from ADR as an alternative dispute resolution. First and foremostly, remove this word as alternative, because mediation or arbitration in itself are pillars of justice. That's exactly what Justice Tejas Karya said. Justice Tejas Karya said in that, where he said that please stop looking at arbitration and mediation as alternate. They're never alternate. They are a specific course of direction given to achieve the desired result. Till the time you continue to look at them as an alternative, the courts will continue to interfere in those. Whether it's a mediation, whether it's arbitration, courts will continue to interfere because they will always feel, oh no, we are the only ones who have the power to decide matters. They are just alternate. So first and foremostly, that whenever Justice Suryakant takes over, he should remove the word as alternate dispute resolution completely from everywhere. And secondly, and more importantly, is when we talk about mediation, as Avishkar correctly pointed out, that more than sometimes lawyers, there are day-to-day technical people. I do a lot of electricity and mining. There are mining tribunals, there are electricity tribunals, there are electricity commissions as well. Now, for example, in Rajasthan, there's a Rajasthan Electricity Regulatory Commission where none of the member is a judicial member right now. But day in and day out, matters are being decided very judiciously. So on that aspect, you don't need judicial mind to decide judiciously, first of all. You need a mind wherever a matter is of technical nature, a technical supervision, and a technical know-how is what is necessary. For example, in APTIL or before the NCLAT as well, you have a technical member. In the same manner, a mediator who is a non-lawyer but knows the subject matter at hand would do way better than other lawyers who are in the sphere. And to be very honest, as Avishkar rightly pointed out, it might be against the lawyers, but thankfully there is no dearth of work for all of us. So we might look forward to something where new people come into picture, new expertise come into picture, and that would be really helpful in the long run. I would just hope and pray and wish my complete luck to Justice Suryakant's vision, because his vision will probably aid in removing the word alternate from alternate dispute. Thank you.
Thank you for the closing comment, Advocate Karthik Seth. I'll go to Advocate Aditya Chowkar, who joins us from Bombay High Court, the city of Mumbai, for his closing comment.
Thank you, Tarun. Well, I have to, of course, wish Justice Suryakant our full cooperation for this great initiative, not just our luck, because as Avishkar says that lawyers could be shooting themselves in the foot. However, us being lawyers, I'm sure we'll be enroll as mediators sooner rather than later if our kids get this thing and do a great job of it. So one way or the other, we are all behind Justice Suryakant. That is the first aspect. Again, what I'm focusing on is that I am very concerned about how these mediations would work at the grassroots level, right? Uh, Not in a metro city like Delhi or like Bombay even, but in a municipal court, right? Those are matters which go up in appeal. They don't clog just one court's docket. They keep going up and magnifying the issue. So my hope is that those 30,000 mediators are the first step, and then they are also asked to train 30,000 more, perhaps, one-on-one, mentor future mediators. And not just that, somehow I feel that there has to be, over a period of time, some sort of an assessment done. Because, see, the villages already have an informal system in place to take care of problems because everyone knows everyone. And commercial cases, let's be very honest, a lot of commercial cases come out of ego also. People with money usually fight because they can afford to. I do not know whether those matters would really reduce, anytime soon. But for those people for whom fighting is not necessarily an option, but they do not see an alternative, I think this could be fantastic. And it could really de-stress the judges also, not just declog the system. Because I can see, in sometimes when I come to Delhi, sometimes when I look at the board in Bombay, sometimes we see 100 matters on board. I do not know, I can't begin to imagine what will be going on in a judge's mind when he sees that his cost list is 100 matters and you have, like, say, 7 to 8 hours of sitting. A lot of judges in Bombay are sitting beyond the designated time of 5 o'clock, and that is because they want to get all these things sorted out. So I think if we can reduce the pendency in court, fantastic. If we can actually make sure this works at a local level, I think it would be a resounding success. And I would really wish Justice Suryakant all the success in this initiative, because this is something worth talking about and fighting for.
Indeed, West, with pendency shooting through the roof, this is what the doctor ordered, in this case, Justice Suryakant, who's sort of got behind it with full gusto. The good thing is he's going to give us a report card, get it audited by the Judicial Academy, Bhopal, and results will be for all of us to see. I'll go to Advocate Karmanya Singh for his good wishes for Justice Suryakant A, and also one suggestion that he would like to give. Over to you, Karmanya.
Yeah, so I think Justice Suryakant has nailed it, with mediation being the key for bringing disposals up and reducing pendency, because the chances of appeals and all of that whole cycle stops. I just want to cover one thing that I've seen from like personal experience in Delhi with the IP matters, that they've seen a lot of success in the mediation center. And I think the fundamental reason behind that is like a fear of immediate finality. So if you know that the simple trademark disputes and copyright disputes, and maybe even some patent disputes, they will be decided in a time bound manner, and you'll get injuncted or you'll have some sort of consequence to you. So I think if the Supreme Court can identify certain key areas like domestic violence cases or challan cases, set out some clear principles on how these mediations need to be run, I think it's a low hanging fruit that, with some principles like convenience, technology, and informality, which Avishkar covered, and it being confidential, I think the fact that lawyers will then be able to advise their clients that it's better to mediate, because the consequence at the final level at the Supreme Court or the High Court is going to go against you, or there is a clear uncertainty, it's better that you resolve this privately between yourselves. I think that approach, where it starts from the top down, as well as empowering the mediators at the bottommost level to do mediation in an informal and tech friendly way, I think both of those, when they converge, they will lead to a lot of meaningful resolutions between parties, where everyone comes out with a feeling that they've won in this dispute.
And your good wishes for Mediation for Nation?
Yeah, I think I just want to wish Justice Suryakant and the whole judicial and legal system a very, very big all the best. I think mediation has to be the way we go forward, and I don't think lawyers are going to miss out on any work. I think it just means we'll have to be more reasonable, and we'll have to negotiate better on in the presence of a person who doesn't get to just decide. So I don't think it's a negative. I think it's a very positive outcome for the whole nation, from the bottom to all the way to the top.
Good you said that, because any such program cannot do well without the support of the bar. And when the bar is standing behind Justice Suryakant, this will be a success. I would like to thank Advocate Avishkar Singhvi, Advocate Karthik Seth, Advocate Aditya Rajgaonkar, who joins us from Mumbai, from Bombay High Court, Advocate Karpande Singh, currently abroad but made it short in time. Good to see you. Thank you for your time and support for Mediation for Nation. May this be a great success, and part 2 may be much even bigger. Appreciate your joining us. Thank you so very much. Thank you.
Thank you so much, Tarun, for covering this.
Thank you.